Good evening, one and all present here. Myself, Dr. Bhuvaneshwaran, Assistant Professor, PG and Research Department of Commerce. I would like to present the subject Corporate and Economics of Law. Let us introduce Introduction of Corporate and Economic of Law. So, the Corporate and Economic of Law is that law to study the policy and the principles of the corporate people. So, the economics of corporate law is the study business corporation using microeconomic concept and the tools. The focuses on the rules and regulations of the people. So, especially the protect the corporate people. That is the corporate and economic law. So, what are all the duties and responsibility to protect the corporate sector? That is the duties of the shareholders, creditors, directors and officer are some of the main areas on the focuses of the particular law. That is called as a corporate law. Next important definition, that is the capital accounting transaction. The capital accounting transaction is the financial transaction that change the assets or liabilities of the people in India or outside India is called as a capital accounting transaction. What is the main purpose of the capital accounting transaction? The capital accounting transaction is the buying or selling of the assets such as real estate, patents, stock, bonds and derivatives. So, the making of investment in the foreign entities like such as the overseas direct investment and foreign direct investment, acquiring movable property from the outside India, forgiving debentures, the conditional grants for capital projects, transfer of assets between the resident and the non-residents. That is the main features of the capital accounting transaction. Next, realization and the repatriation of foreign exchange. The realization is the repatriation of foreign exchange is the process of converting foreign currency into Indian rupees and sending it back to India. That is the realization and repatriation of foreign exchange. According to the section 8 of the Act requires the process of converting foreign currency into the Indian rupee, resident in India to make all the reasonable efforts to realize repatriate the foreign exchange due to as per the direction of the RBI. So each and every aspect must be comes under the RBI. So for example, if a Lay Limited sold goods to Mr. X, a person resident outside in India, and later Mr. X refused to make such payment and was untraceable. Now this will be the duty of A Limited. So the A Limited is a Indian resident to take responsible steps to recover the amount from the Mr. X, or otherwise the report the matter to the RBI. Next one, remittance of assets. So the remittance of assets is the process of sending funds from the India to another country. The funds can come from the sale of assets, bank deposits and the insurance is called as a remittance of assets. Those assets is pre-approved from the RBI, that is the Reserve Bank of India. The approval must be approved remittance of funds from the sale of capital assets in India except provided the FEMA Act 1999. So what is the rule to prohibition of the remittance of assets? No person, whether the resident or non-resident, can remit the asset held in without permission from the RBI. It should be prohibited from the remittance of assets. Who permission to remittance of asset? The RBI can permit to person to remit the asset for certain reasons. It is called as a remittance of assets. Next one, repatriation. The repatriation is main purpose. The non-residential Indian or the foreign citizen can repatriate up to $1 per financial year is approval. Next, sale of proceeds. The sale of proceeds, the NRI and PO can remit the sale procedures of immovable property in India subject to certain conditions is applicable. Liberalized remittance of schemes. Liberalized remittance of schemes are those schemes individual who are the residents in India can remit the amount outside of India for various purposes of liberalized remittance schemes under the non-residents and cannot be remitted among the particular act. Next one is Foreign Exchange Management, that is Possession and Retention of Foreign Currency Regulations Act 2000. Okay, this act main purpose is a person can possess the foreign currency without any limit. A person possesses any foreign currency without any limit, but an Indian residents can certain restrictions. So only the authorized person can deal the foreign currency under the FEMA Act 1999. So what are all the possession? The possession with the limited of foreign currency and coins by authorized person within the scope of his authority is only the concern. Second, the possession without limit of foreign coins by any person is one of the limitations. Next, redemption by the person resident in India of foreign notes, bank notes and foreign currency travelers checks not exceeding the 2000 US dollar or equivalent to aggregate provide such foreign exchange in the form of currency notes, the bank notes and the traveler check is comes under the Foreign Currency and the Redemption Act. Next one is it was occurred by him while on a visit to any place outside in India for the purpose of visiting or purpose of visiting the company in the abroad. The way of payment of service not arising from the any business or anything done in India. Second, it was occurring by him from any person not resident in India. Not resident means India means does not fulfill the residential status of the conditions and who was on the visit in India. Honorarium and a gift for the service rendered by him in settlement of any lawful obligation comes under the particular act. Next, authorized person. Who is a authorized person? The authorized person is a person who deal on behalf of the company. The authorized person is a person who deal the foreign currency on behalf of the company is called as a authorized person. So the authorized person comes under the RBI, that is Reserve Bank of India. So adjudication. Adjudication is the legal ruling and the judgment. Usually the final judgment will be given by the particular act. It can also refer to the process of resolving any legal disputes against the particular act. If it is not favor for the particular people, the request to challenge the decision made by the adjudicating authority to the people to appeal against the authorized dealers. Next one. Next, Unit 2, Competition Act 2002 and the Consumer Protection Act 2019. First of all, what is meant by Competition Act? The Competition Act introduced in the year 2002 is a law regulates the competition in India and protect the interest of the consumers. So this act was passed by the Parliament of India in the year 2002 and replaced the Monopoly Restricted Trade Practices Act 1969. The main purpose of this act is to preventing the anti-competitive practices and to protect the consumers and ensure the freedom of trade of the particular act. Next one, objectives of Competition Act 2002. The main objective is the following the main objectives. First one, to prevent the practices having adverse effect on competition and to promote and sustain competition in the market is main objective. Second one, to protect the interest of the consumer. Suppose the consumer is any unfavorable situation, the consumer can protect the interest against the particular competition act. The third one, to ensure the freedom of trade carried on by other participants in the market in India is one of the objectives. And fourth one, for matters connected therewith and incidental thereto is one of the main objectives of the particular Competition Act. Next one. prohibition of certain agreements, abuse of dominant position, and the regulations of the combinations. So, prohibition of certain agreements. So, what is meant by agreements? Agreements is a mutual understanding between the two parties. So, agreement is equal to offer plus acceptance is the agreements. What is the prohibition of agreements? The prohibition of agreements between the competitor in the same or similar business of the product. And agreement between the business at a different supply chains of the product is the main prohibition of agreement under the Competition Act 2002. So, what is the anti-competitive agreement? According to section 3, the anti-competitive agreement is one of the agreement directly or indirectly determines the purchase or selling price is the anti-competitive agreement under the Competition Act 2002. The second one, limits or control the production. So, limit or control the production, supplies, markets, technical development, investment or provisions of the services is one of the anti-competitive agreement under the Competition Act. And third one, the share the market or sources of production or provisions of services by way of allocation the geographical area or type of goods and services or the number of customers in the market or any other similar way to be the anti-competitive agreement under the particular act. So, the people or comes there directly or indirectly result bid rigging. Bid rigging means illegal business activities comes under the particular competitive Act 2002. It will be the considered as a anti-competitive agreement under the section 3. Next one. Abuse of dominant position. Section 4. Abuse of dominant position. The abuse of dominant position. A company dominant in the market share uses its power to calm competition. Prohibition of abuse dominant position by an enterprises or group. If the people, the most of the company or the large scale company, they have two dominant position in the market. So that the dominant position to harm the competition between the smaller company. The smaller company directly or indirectly affected by the large scale company. So, what that is one condition in purchase or sale of goods and services is one of the factor, and the second one prices in purchase or sale including the goods and services, and limits or restrictions abuse the dominant position in the large scale sectors, and protection of goods and services or market therefore is one of the large scale company can control over the small scale industries in that way, and the technical or scientific development related to goods and services to the prejudice of the consumer to dominate to the small scale industries in the large scale sector. Next time, combination. Combination under section 5. The combination is the enterprises of the person or enterprises, if any acquisition of control, shares, voting rights or assets of enterprises by another person. So the best examples of combination is the amalgamation. So amalgamation is the best examples of the combination. The amalgamation is captured and the two or more company going to liquidation in the form of new company. The new company take over or acquisition the control over the entire company. That is the shares, voting rights or assets of an enterprises by the another reason to control the combinations. So any acquisition, the parties the acquisition being the acquirer and the enterprises both control the shares, voting rights, assets have been acquired being the jointly to have the business is one of the reason to the combinations. The regulations of combination. As per the section 5, no person or enterprises shall enter into the combination which causes or is likely to cause appreciably adverse effect on competition within the relevant market in India. Such as combination shall be the void according to the particular act. Next one, Competition Commission of India. So the Competition Commission of India is one of the statutory body within the Minister of Corporate Affairs and is responsible for enforcing the promoting the competition. So the Competition Commission of India is only the only the commission to promote the competition in that market. So nowadays the competition is more powerful tool in India. So in the previous year we have to focus on the monopoly market only. The monopoly market single by a large number of seller. Nowadays the monopoly competition. The monopoly competition, large number of seller, large number of buyer is available in that market. So that the section 7 provides for establishment of Competition Commission of India. The commission shall be body corporate by the first named having perpetual succession and a common with the power to acquire the particular act. So the composition of commission. The composition of commission according to section 8, the composition of commission shall consist of the chairperson is the main headed person and not less than 2 and not more than 6 of the other members appointed by the central government of India is the one of the composition of commission under section 8. Next, duties of commission according to section 18. The duties or the following are the duties of the commission. This section provides that shall be the duties of the commission to eliminate practices having the adverse effect on the competition under the Competition Act. So first, what are the duties of the commission? First one, to promote and sustain the competition in the market in India. That is to protect the interest of the consumer is one of the main aspect of the Competition Commission, main purpose of the duties of Competition Commission. Second one, to ensure the freedom of trade carried on by the other participants in the market in India. So each and every people they have to freedom to continue the trade or business in India. So the competition commission is one of the main duty to ensure the freedom to trade of the people. Third one, the commission may be the purpose of discharging its duties or performing its function under this act is one of the duties of competition commissions. And again, another one, any memorandum or arrangement within the prior approval of the central government with any agency or foreign country is one of the duties to competition commissions. Next, appellate tribunal. So what is meant by appellate tribunal? Appellate tribunal is a court of law that appeals from the lower court to higher court. The appeal from the lower court to higher court, that is the appellate tribunal. The appellate tribunal is here the appeals against any direction against the people to decision made in order to pass by the commission. They can appeal against the lower court to higher court. So what is the composition of tribunal? The tribunal shall consist of the chairperson, not more than 2, and other member appointed by the central government of India. Next one, Consumer Protection Act 2019. So the main purpose of Consumer Protection Act is the law in India that protects the consumer from the unfair business practices. The act provides the way of consumer to file the complaints and receive the compensation from the consumers. So the main purpose is to protect the consumer from unfair business practices and provide way of consumers to file the complaints and allow the consumer to receive the compensation for hardship, strengthen the consumer protection provisions, especially online transactions, is one of the Consumer Protection Act 2019. Next, rights of the consumer. What are the rights of the consumer? The consumer have right to information on various aspects of goods and services. This could be information about the quantity, quality, purity, potency, price and the standard of goods or services. If any consumer from the India, the right to information, they get the information from the various aspects, that is goods and services The information, there could be information from the quantity of the product, quality of the product, the purity of the product, potential of the product, price and the specification of product. Each and every aspect the consumer, they should know the rights for the consumer. Second one, to be protected from the hazardous goods and services, right to protection against the goods and services that can be dangerous to life and property is one of the rights of the consumer. And the third one, to be protected from the unfair or restrictive trade practices is one of the rights of the consumer. The consumer have the rights to access the variety of goods and services at the competitive price is one of the rights of the consumer. The consumer should have rights to redressal any from that product is one of the rights of the consumer under the Consumer Protection Act 2019. Next. Consumer Dispute Redressal Commission. So the Consumer Dispute Redressal Commission, that is the CDRC, the Act has provisions of the establishment of Consumer Dispute Redressal Commission, the national, state and district level to entertain the consumer complaints. So the Consumer Dispute Redressal Commission that must be functioning under the national, states, district levels to receive the complaints from the consumer is one of the main purpose to Consumer Dispute Redressal Commissions. So, as per the notified rules, the state commissions will furnish the information to the central government on the quarterly basis on vacancies, disposals and petitions of the cases and other matters related to the consumer disputes and redressal commissions. So, the CDRC will entertain the complaints related to the following aspect, that is the overcharging and deceptive charging is one of the complaints received from the consumer as per the Consumer Dispute Redressal Commissions. So if it is any received the complaint from the consumers, it must be rectified within the day or more than 15 days it should be the follow. The unfair and trade practices, the sale of hazardous goods and services which may be hazardous to life is one of the consumer disputes to be redressal on the basis of the commissions. So as per the Consumer Dispute Redressal Commission, the rules is there will be no fees for filing any cases. If it is receive the complaint from the consumer, there will be no charges will be filing any complaint from the particular Consumer Dispute and Redressal Commissions up to 5 lakh. Next. The Central Consumer Protection Council. The Central Consumer Protection Council, the Act empowers the Central Government of India to establish the Central Consumer Protection Council. It will act advisory body on the consumer issues. The consumer issues as per the notified by the Central Consumer Protection Council rules. The Central Consumer Protection Council would be headed by the Union Minister of Consumer Affairs, Food and Public Distribution, with the Minister of States as a Vice President and 34 other members from the different field of particular Consumer Protection Council. The council which has 3-year tenure, the consumer which has appointed as a 3-year tenure will have the minister in charge of the consumer affairs from the 2 states from the each region, that is the north, south, east and west. There is also the provision having the working groups from the against the members of specific task. Next, procedure on receipt of complaint from the consumer. What are the procedure from receipt the complaints from the consumers? So, the district forum shall receive the complaints against the consumer. The complaint must be related to any goods is one of the main matter. So, they refer any copy of the complaint to the opposite party mentioned in the complaint, directing him to his version of the case within the period of 30 days to be solve the particular complaint, or such extent period not exceed the 15 days of the complaint received from the district forum. Second one, where the opposite party on receipt complaint referred to him under the clauses denies or dispute the allegations contained in the complaint or omit or fails to take any action to represent in case of the time given the district forum. So that the time maximum limit is 15 days to resolve the particular complaint against the consumers. Appeal against the order. The consumer can file the complaints against the Consumer Protection Act. The consumer cannot be satisfied about the complaint. The appeal against the order. The appeal, any person aggrieved by an order may be made by the district forum, may be prefer appeal against such order to the state commission within the period of 45 days from the date of order. If it is the consumer cannot satisfy the particular complaint, it can be appealed against the district forum, that is the state commission, within the period of 45 days from the date of the order, such from the manner there may be the provided that the commission certain appeal after expiry of the said period of 30 days, it is satisfied that there was sufficient cause of not finding within that period. Next. Unit 3, law relating to intellectual property rights. So intellectual property rights is one of the property rights, that is a legal protection for the creation of mind, such as invention, design and creative contents. So each and every people, they have some important knowledge about the particular aspect, that is the creation of mind, such as invention, design and creative content. So that creation must be protected under the intellectual property rights. The intellectual property rights are the legal rights which result from the intellectual activities in industry, scientific, literacy and the artistic field. These rights safeguard for the creators and other procedure for intellectual goods and services by granting them certain limited rights to control their use. The protected of intellectual property rights like other property can be matter of trade which can be owned, sold or bought. These intangible or non-exhausted consumptions. Next one, works within the copyright subjects. So the works within copyright subject, the subject to the provisions of this section and other provisions of this act, copyright shall be subject throughout in India the following classes works, that is to say, that is the original literacy, dramatic, musical and artistic work. And second one, cinematography films and records, also the copyright subsists under the particular intellectual property rights. Any copyright shall not subsist in any work specified in subsection other than which provisions of the section 40 and section 41 are applied unless. Next one. The copyright shall not subsist. In any cinematography film, if substantial part of the film is an infringement of the copyright in any other work, in any record may be respect of literacy, dramatic, musical work, if making the record copyright such as work has been infringed under the Copyright Act. Okay, the copyright in a cinematography film or record shall not affect the separate copyright in any works respect of or substantial part of each of the film as a case may be record is made. So in case of the architectural work of art, copyright shall substitute only the character and design and shall not exceed the process or methods of concessions. Next, ownership of copyright and rights of the owner. So subject to provisions of the Act, the author of the work shall be first owner of the copyright of the particular Act. So in case of literature, dramatic, artistic work made by the author in course of his employment by the proprietor of the newspaper, magazine or similar product. That is assignment of the copyright, mode of assignment, transmission of the copyright in the manuscript, and transitory disposition, right of the author, relinquished copyright is one of the ownership of the copyright of the particular act. Next one, dispute with respect to assignment of copyright. So sometimes the Copyright Act, they have some dispute comes under the particular act. If an assignee fail to make sufficient exercise of the right assigned to him, and such as failure not attributable to the any act or omission of the assigner, then the may receive the complaint from the assigner, and after holding such injury as to may deem necessary revoke such assignments. So in every complaint received from under the subsection 2 shall be dealt with as far as possible, and effort shall be made possible the final order to matter within the 6 months from the particular Copyright Act. Next, registration of copyright. So if it is any copyright, they have to register in the following manner. That is the Register of Copyright Act. The Register of Copyright, there shall be kept at the Copyright Office. A register is the prescribed from to be called the Register of Copyrights, in which may be entered the name of the title of works, names, address, authors, publisher, and owner of the copyright must be registered under the Copyright Act. Entries in the Register of Copyrights. The author, the publisher, the owner of the other person interested in the copyright, any work may make an application in the prescribed form accompanied by the prescribed fees to the Register of Copyrights, and enter the particulars of the work in the Register of Copyrights Act under the copyrights. Next one, indexes. So the indexes, there shall be kept at the Copyright Office, such as index of the register of the copyright may be prescribed. So from the inspection of register, the register of copyright and indexes thereof kept under this act. The register of copyrights, the prime piece of evidence, the particular entered in the therein. The register of copyright shall be prima facie of evidence of the particulars entered therein, and documents purporting to the copies of any entries therein, and extract therefrom the certified by the Register of Copyrights. Next, infringement of copyrights. So when the copyright infringes, when any person without licensing granted by the owner of the copyright or Register of the Copyright under this act, in contravention of the conditions of the license granted by the any conditions. So such as the contains the not infringement of particular act, that is the research or private study, criticism or review, whether that work or any other work. So importation of infringement copies. The register of the copyrights on application by the owner of the copyright in any work or by his duty authorized agent on payment of prescribed fee may be after making such inquiry as he deems to be fit for under the Copyright Act. Next, Indian patent law. So patent is very important for the nowadays. The Indian patent laws define the various provisions of the Patent Act 1970. Under this law, patent rights are granted from the inventions. The inventions are made by the particular people, covering a new and invention process, product, article, manufacturing, any events that are able to satisfy the patent's eligibility requirements for having the novelty, innovative steps and the area special. The main categories are the Indian patent law is the qualified or patentable under the IPA Act. An invention whose use could be contrary to the public order or morally, or which causes serious prejudice to human, animal and plant life or health or to the environment. For example, the new type of gambling machine people of industrial applications is one of the Indian patent law. Next one. Next. Trademark Act 1999. So the Trademark Act is one of the most recent act that is currently recognized in India. The visual symbol which is identify any merchants or manufacturer goods or services and distinguish them from the similar goods and services of the competitors in the trade. It may be included the shape of the goods, their packing and the combination of the color comes under the Trademark Act 1999. So conditions for the registration. The following condition for the registration under the Trademark Act 1999. So the basic requirements of the Trademark Act to be recognized and registered in that it is not identical or similar registered trademark in the country in which it is used. In order to mark the registered must be approved intellectual property authorities the registration. The procedure for register the trademark. First one, conducting exhaustive trademark search, filing an application with necessary documents, examination of the application by the trademark registry, post-examination procedure, advertisement of the application in the trademark journals, opposition by the third party. These are all the procedure for register the trademark. Next, Unit 4. Prevention of Money Laundering Act 2002. So, the Prevention of Money Laundering Act. What is the Money Laundering Act? Money Laundering Act is one of the act that is legalizing the money from the illegal people. Legalizing the money from the illegal people. According to the section 3, whosoever directly or indirectly attempt indulge, knowingly assist or knowingly party or actually involved in any process or activity condemned, it must be comes under the Prevention of Money Laundering Act. So the main offence of Money Laundering Act, there are 3 main money laundering offences under the part 7 of the Act. The Money Laundering Act it will discussing, converting, transferring or removing criminal property, and the criminal property must be comes under the legalized way. Next one, punishment for the Money Laundering Act. Any illegal business from the money laundering, whoever commits from the offence of the money laundering shall be punishable with the imprisonment for terms which shall not be less than the 3 years, but which may be extended to 7 years, and shall also be liable to the fine. Next one, attachment, adjudication and confiscation. Attachment of the property involved in money laundering, wherever the director or any officer not below the rank of deputy director of the particular people. The purpose of this section has been reasoned, that is any person in possession or any procedure of the crime. And second one, such procedure of crime are likely to be concealed, transferred or dealt with in any manner in which may result prosecution any proceeding relating to the particular Money Laundering Act. Next, adjudication. So adjudication is one of the process. The process may be that the adjudicating authority has a reason to believe that any person has committed thereon. The adjudicating authority shall be the considering the reply, if any, to the notice issued under section 1. The hearing and the agreed person by the director, any other officer authorized by him is one of the Money Laundering Act. Next, obligations of the banking companies, financial institutions and intermediaries. Next one, summoned and search and seizure of appellate tribunal. Search and seizure is one of the main purpose of appellate tribunal. Next, Unit 5, Real Estate and Development Act 2016. The Real Estate Real Estate and Development Act is one of the important act that protect the people from the particular real estate and Act 2016. So the salient features of the Real Estate Act, that is establishment of regulatory authorities, mandatory registration, public disclosure, consumer protection and dispute resolution, financial declines, promoters and accountability, equality and all buyers and promoters, legal representation, penalties and enforcement applicability. Thank you, one and all.